Welcome to Diagnosing Health Care, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. While these issues may seem like hurdles, we'll also look at the business opportunities and solutions that exist. Diagnosing Healthcare is brought to you by the lawyers at Epstein Becker Green, a leading law firm that has decades of experience serving clients in the healthcare and life sciences industries nationwide.
Today on Diagnosing Healthcare, we will discuss the latest developments in healthcare antitrust and what recent changes might mean for hospitals and health systems. Hello and welcome. I'm your host, Will Walters. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Washington, D.C. office. Somehow the holidays are already just over the horizon, but way back in July, the Federal Trade Commission and Department of Justice released updated draft merger guidelines, and the FTC earlier in June published proposed amendments to the Hart-Scott-Rodino pre-merger notification rules. Between these updates and a recent focus on labor, it's hard to say who had a busier summer, lawyers at the FTC or the EBG attorneys who are tracking their thinking. On today's show, we're going to dig into the latest developments in healthcare antitrust and hopefully learn a little bit about how the FTC is viewing mergers in healthcare markets. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts. Joining our discussion today is Trish Wagner, General Counsel and Chief Privacy Officer based out of EBG's Washington, D.C. office. Trish counsels healthcare and life sciences clients in two of the most complex areas affecting their business: privacy regulations and antitrust issues. A scientist as well as a lawyer, she brings a deep understanding of healthcare to developing creative, pragmatic strategies to minimize risk. Hello, Trish. Thanks for joining us.
Thank you, Will. Happy to be here.
Also joining us today as a member of the firm out of our D.C. office is John Steren. John leverages his more than 30 years of healthcare antitrust and litigation experience to help healthcare clients manage the risks of joint ventures and other business arrangements and to defend them against government investigations and enforcement actions. He also provides counseling and litigation services to employers in connection with non-competition and pricing related issues. Thanks for joining us today, John.
Thanks, Will. Happy to be here.
I'm also happy to welcome Jeremy Morris, a member of the firm in our Columbus office, to today's episode. Jeremy is a trusted antitrust counselor and advises his clients on how federal and state antitrust laws impact business, especially in the healthcare industry. Clients value his practical, solution-oriented advice, which helps them achieve their business goals. Thanks for joining us today, Jeremy.
Thanks, Will. Appreciate you having me.
So we'll start with the changes to the merger guidelines. Why don't we talk through what changed and which of those changes will be most felt in the healthcare sector? Trish, we'll start with you.
Yeah, and I think I'm going to start by backing up just a little bit and think about this from 20,000 feet. And what I think we're seeing is a continued shift by the agencies, almost a paradigm shift on how to evaluate transactions. But when we do that, we have to remember a couple of things. First of all, these are proposed guidelines, and even when or if they become final, they are still just guidelines. They're not the law, but they do provide us insight into how the agencies will be reviewing transactions and how they're thinking about transactions as they move forward. The catch is also that traditionally courts have shown great deference to the guidelines. So as the guidelines become more and more commonplace and more in use, the courts will often defer greatly to the agency as to how those guidelines should be interpreted and how transactions should be evaluated looking at those guidelines. So there are a number of proposed changes. I'm going to start maybe with the first one, which maybe is the easiest one to talk about because it's a shift on the view of concentration. And that's guideline 1. And ultimately what the change does here is it lowers the concentration threshold for the presumption that a transaction would be illegal. And to put that in perspective, the proposed guidelines do that in two ways. One, they lower the HHI threshold. Currently, it's at 2,500 for a transaction to be presumptively illegal. They would lower that to 1,800 with an increase in HHI of 100. They also include a second test for demonstrating that the concentration threshold would be presumptively illegal or would mean the transaction would be presumptively illegal. And that is if the market share is greater than 30% and there's a shift in HHI of greater than 100. And both of those tests could have pretty significant impacts, particularly in the healthcare industry, where, for example, in most towns, there aren't a lot of hospitals. And so lowering the threshold could have a significant impact on how transactions are viewed in the healthcare space.
Thanks. And John, what would you add to that?
Thanks, Will. I agree with Trish, everything you just said. And I think that from the hospital perspective, the change to the concentration levels that are reflected in Guideline 1 may be the most significant and maybe the reason why they're way up front. It is a throwback from some of the older guidelines. What was interesting, I think, in the change that I think occurred in the 2010 guidelines was the agencies had recognized that the harsher, so to speak, concentration levels were something they didn't go after. So the fact that they have reverted back to these old numbers might suggest even more so that they're going to really look at mergers that raise these level of concentration. And as Trish said, many of our clients do operate in small markets with only a few competitors. Putting it more in some context, under the proposed guidelines and the proposed HHIs, if you had a 7 to 6 hospital transaction, and many markets have less than 7 hospitals, but if you have a 7 to 6 hospital transaction with each participant having equal shares, that would result in an HHI above the 1800 level and a change in HHI of 408, which would create a presumption of illegality. Similarly, the situation where you had a merged firm with greater than 30% market share and a change of 100 points, that could theoretically create a presumption of unlawfulness even in unconcentrated markets. And then finally, talking about the tendencies towards concentration and change in the HHI of 200, there is some prospects of a merger of 9 to 8 hospitals of equal size firms could raise a presumption of illegality under the draft merger guidelines. So there clearly is heightened concern for our hospital clients. Let me just touch briefly upon 2 other guidelines that I think are of some particular significance. It's Guideline 2, which talks about the head-to-head competition between transacting parties. We've always known that the agencies have focused on the level of competition between the 2 transacting parties, but previously have always looked at that as in the context of the concerns in the market. Under the revised Guideline 2, the suggestion is that if there's significant competition between the transacting parties, that alone may be enough for the FTC to go after the transaction without reverting to the context of the rest of the market. And then finally, the last one I want to touch upon, they're all important, would be Guideline 6, which is one that talks about vertical integration. For the first time, we now have a presumption of unlawfulness in a situation where a transaction creates a foreclosure above 50%, it would be presumed to be anti-competitive under the new merger guidelines. So there definitely is a lot of changes here and a lot affecting our clients.
Got it. And Jeremy, what have you been focusing on related to the guideline changes?
Taking off on what John just said, and that they're all important. We've looked at all of them, but a couple that kind of stood out to me were 8 and 9, if you kind of look at them together. 8 is dealing with a trend in concentration, and 9 is dealing with a merger that could be considered a part of a series of multiple transactions. We've had this trend or this concern from the agencies before of situations where a party might have a series of small transactions and whether or not that creates an antitrust risk. But until now, there really had not been specific guidance on this issue. So I think these guidelines clearly indicate the agencies are wanting to start more fully considering this topic and now are giving themselves some tools with which to do so. And I think that's, as a practitioner, when clients have called me in the past and said, here's the potential transaction that we're thinking about, what antitrust concerns might we have? I think I've almost exclusively in the past asked them about, well, tell me about this deal. I think what these 2 things mean is we have to start looking at what else is going on in the market, maybe not even involving you, because 8's talking about a trend of concentration in the market. And then in addition, you also have to start asking those individuals, what other deals have you been involved with such that you might see this trend that the FTC or DOJ thinks is problematic. And so you could start to find a situation where a particular deal is okay, but when you look at it in context of everything that's going on in the market or in the context of what's been going on with that particular party, they start to raise an antitrust risk. I think that's a shift in where we've traditionally been, and that's something new to start thinking about.
Thanks, Jeremy. You probably could have scheduled the whole podcast just on the updates to the guidelines, but there's a lot more going on out there. So we'll shift the conversation to that. And sticking with you, Jeremy, why don't we shift our focus to HSR reform? So what's changed on the pre-merger notification front?
The form has been around for a long time, and not a lot of changes have happened to that form. And I think, the practitioners involved in filing these HSR notifications, we have a pretty good understanding what we have to disclose, the documents that we have to gather. We have a good idea of what's out there. In summary, they've just proposed adding a whole lot of information and requiring a whole lot more information and documents than were previously required. So, for instance, I think let's try to put a little context on that. The agency's own estimation is that the new requests will likely add, on average, about 107 hours to a party's preparation in filing the notification, and increasing the estimated time to file a notification from about 37 hours to about 144 hours. So you can see that's a significant amount of work. And it's worth noting that's a significant amount of work on everyone. So the transaction might not be a transaction that raises significant antitrust concerns, but you're still going to have to go through this additional filing. So I think you're seeing a lot of people saying what it really is almost a mini second request. So used to, you would file the traditional, I guess what we'll call the existing HSR notification. And then if there were concerns, the agencies would come back and file a second request. Now they're moving a lot of the information that they previously would ask for in a second request upfront in the initial request, and they're having all the parties do it. So it would be a big change in the way we do things.
John and Trish, have you been spending hundreds of hours on these forms?
We've been spending a lot of time looking at the drafts. They're not quite adopted yet. They're still under consideration. The hours that Jeremy just threw out come from the LMB analysis. And to make it a little more scary, that's the average increase, which means that there's going to be clients with significantly more time required to get these forms done. We could talk for a long time, just like the new draft guidelines. We could talk for a long time about what the new proposed form requires and gets to. I mean, it gets down to related parties. It gets down to directorate overlaps. It includes all sorts of narrative requirements, which is going to give the pre-merger notification office the ability to sort of scrutinize our narratives. And it's really going to be a transition from what we're all used to more of a European style analysis. And I really wonder, just speaking out loud, the agencies only have 30 days initially to review the form. Are they really going to be able to review all of this information in 30 days? I wonder if that's going to be the case.
I agree with that, John. I find it hard to imagine how the agency could review all the information they're requesting in 30 days. And, to put a little more color on it, even things where we would previously provide 4C documents related to officers and directors, and the proposed form would expand that to anyone who's a supervisory deal team lead. So now your number of 4Cs and types of documents has just expanded. The other thing that they're asking for is responsive transaction-related documents, including drafts that went to an officer or director or supervisory team lead. As you can imagine, in a transaction, the deal document itself goes back and forth multiple times. There are sometimes hundreds of drafts. So it could be pretty sticky, including sorting out which ones are privileged and which ones aren't. So I think that the amount of information that the agency will receive is tremendous. I also agree with Jeremy that it's almost a mini second request. And two things maybe highlight that for me. One is the requirement to identify the communications and messaging systems used, which should have nothing to do with the initial 30-day review of the transaction. And the second is a voluntary request to waive the disclosure exemption to state attorneys general. Or in other words, allow the FTC to disclose the information included in the HSR form to a state AG. Usually the agencies have to get the waiver by the parties in order to do that, and they're trying to build that into the form.
Got it. Thank you. So let's turn the discussion to the FTC's recent focus on labor. John, what should we be watching here?
It really is a continuation of just sort of the expansive focus that the FTC and DOJ have been bringing to the substantive area of antitrust. The issue about labor actually goes probably back to the 2016 guidelines for human resource professionals, which is when the FTC and DOJ came out with these guidelines that really sort of put people on notice and the industries on notice that they were going to take labor issues very seriously. I think those guidelines talked a lot about the differences between per se violations and what might be considered a rule of reason worthy type of fact pattern, and focused more on wage issues. And then with the Biden administration and the executive order that came under the Biden administration, it sort of expanded upon labor being an important element of their focus. And it's just sort of morphed in now into the merger analysis. And we were just talking about the changes to the pre-merger notification form. Some of the form now is focused on labor-related issues. All of us on this podcast have seen the questions related to labor in the context of a second request. We know that they've asked for information related to labor issues and wage issues. They are keenly aware of it. I have yet to see an actual enforcement action when it comes to a merger and how it might impact labor, but I think that's on the horizon. And to give ourselves a plug for our latest Antitrust Bite blog, we talked about the recent MOU between the FTC and the Department of Labor that addresses some efforts to share information and otherwise so that they can look at labor markets more carefully. So I think in the not too distant future, I think we'll see some more enforcement actions addressing the impact of mergers and labor markets.
Trish, we'll turn to you.
Well, just to dovetail on what John is saying and maybe emphasize the point, in one of the proposed merger guidelines, guideline 11, which is about when a merger involves competing buyers, there is actually a discussion about how buyers include labor buyers. So it is clear that they are staking ground to the fact that they will be considering labor markets in looking at transactions. What I don't know, and it's possible that the agencies themselves don't know yet, is how that will be evaluated in terms of a transaction. It's a little hard to imagine a merger being stopped just based on labor concentration. Not that it couldn't happen, but it's a little hard for me to imagine just because people tend to be able to move between jobs. People are able to get jobs at other places. So it will be interesting to see what kind of guidance comes out related to the labor market issues.
And Jeremy, what would you add here?
First, that I completely agree with Trish and John. I think they've kind of covered a lot of the area, but I think the one thing I would add is, to me, it has been somewhat eye-opening that when you do read what the agencies put out or listen to any enforcer, how often this topic comes up. It is something they seem to just constantly be beating the drum about, is how much they are now considering the labor markets when they are conducting an analysis of antitrust issues. You would go to conferences previously, and what you always heard about was consumers and purchasing products, and they still say that, but they spend just as much time almost these days, it seems to me anyway, talking about the labor market. So I don't know when that day is coming, but I do agree it's on the horizon, and they do seem to have a significant focus on that area.
Excellent. So John, you mentioned our Antitrust Bite blog that we all write. So we're going to do a little bit of that in podcast form now with just some short answers for each of you. Trish, we can start with you. So we've discussed a lot today, but what is the one thing that you will be watching most closely over the next few months?
I'm not sure I can narrow it to one, but I definitely will be watching to see when the merger guidelines are final, and I will be watching to see what happens to the form. The other thing I'm watching, which we didn't have time to talk about today, is that the FTC and DOJ have both now withdrawn the statements of antitrust enforcement policy in healthcare. And for many of our healthcare clients, that essentially was the Bible. That's how a lot of joint ventures were structured. That's how clinical integration programs were structured. So I will be really watching to see whether the agencies have decided to replace that guidance with something else.
Jeremy, so after the FTC's very busy summer, are we expecting any more large sweeping changes out of the FTC?
Oh, the crystal ball question. That one's difficult. So especially now, if you had asked me a year ago, are they going to withdraw the merger guidelines? I probably would have said, no, they're not going to withdraw the merger guidelines. Or as Trish said, the statements of enforcement in healthcare. No, they're not going to do that. Things are hard to tell, but what I think what I'm looking for now is they have withdrawn some of this guidance. They have proposed new merger guidelines. They do seem to be setting the field with new tools to say, here, we want to pursue actions, enforcement or otherwise, based on these new statements that we are going to put out, new guidelines that we are going to put out, new information that we're going to want to acquire as part of that potential new HSR filing requirement. So I'm interested to see how they're going to use that new information and how they're going to utilize those new guidelines and those new, if you think about it as enforcer tools in their toolkit, to say, here's what we might want to go after, or here's what we might want to now see how a court would react to these. That's what I'm watching for.
John, you get another crystal ball type question, but a little different. Assuming we have another episode of the Diagnosing Healthcare podcast focused on antitrust around this time next year, what do you think we'll be talking about then?
This time next year, we should have a yay or nay on this draft merger guidelines and the proposed HSR forms, draft to the HSR form. And picking up on what Jeremy just said, I think that the enforcers are taking the position currently in some of their enforcement actions that what's written in the draft guidelines is what they are utilizing today as part of their enforcement perspective. And so if parties continue to push back on some of this, which I think is the right way to do it, we may have some transactions or some other activity in litigation, which may give us some insight as to whether or not the courts are going to adopt and accept some of the principles that are announced in the merger guidelines. And I do think there's some questions as to whether or not what's in there is, in fact, the right outlook for antitrust law.
Well, Trish, John, and Jeremy, thank you all so much for taking the time to participate in today's discussion on antitrust in the healthcare sector. And thank you to all of our listeners. I'm your host, Will Walters. If you like what you've heard today, please don't forget to subscribe. Diagnosing Healthcare is available wherever you get your podcasts.
Thank you for listening to Diagnosing Healthcare. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.